and we're recording this session. But first of all, I would like to acknowledge that I'm hosting this Zoom training from the lands of the Yagara and Turrbal peoples. And I wish to acknowledge the traditional custodians of the land upon which you're all on today, and to acknowledge any First Nations peoples present this afternoon, and to pay my respects to elders past, present and emerging, and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of Queensland. A couple of housekeeping duties before we do get started. There you are, Tamika, hi. A couple of housekeeping duties. Look, with such a small group, you can just unmute yourself, and shortly Dan, I will hand over to Dan, and Dan is running the session this afternoon. But you've got a couple of options if you want to ask a question or make a statement or comment. You can certainly use the reactions button down the bottom of the screen to raise your hand if you want to say something, and hopefully Dan and others will notice that and we'll let you talk. Or you can type a question or some comments in the chat box, or you can simply unmute and just say, hey, Chris, stop. I just want to ask a question. Or Dan, can you go back one slide? So feel free to do that. You know, type it in, raise your hand, or just unmute and jump in. If we had 50 people, we couldn't do that, have 50 people just jumping in and unmuting, but there's only Tamika and Linda online, so happy for you just to unmute. If you've got any questions or you just want to stop down there for a moment, please do so. I don't really have any other, they're not rules, but Zoom etiquette, if you like. So I will hand over to Dan, and he'll run you through the session. I'll just let you know, Kelly Dwyer and Leanne Jiggins are both professional officers with the QNMU, and they're also here to answer questions and assist you. All righty, thanks, Dan.
Thanks so much for that, Chris. And thank you very much, Tamika, Lindsay, and everybody for joining us today. We do note that this session is also being recorded, so hopefully it may be able to act as a bit of a resource to others. As Chris said, we're happy to run a bit of an informal kind of back and forth here. So if at any time throughout the process you have any questions, please don't be afraid to speak up as well. Now, before we get started, I just want to check, can everybody see the screen that's currently on?
I've just got a blank screen. It just tells me you've started screen sharing.
Yeah, I've got a black screen too.
No worries. How about now?
No.
No.
All right, guys. So the Queensland Nurses and Midwives Union, particularly focusing on the public sector. As you would be very aware, nurses and midwives practice in a professional environment which is strictly governed by laws. You're likely to be familiar with many of these laws. Regulations regarding Schedule 8 medications, proper documentation, infection control guidelines, manual handling techniques. These are just a few of some of the standards, regulations and rules, and thank you, Ebony, that have been drilled into you since you decided to become a nurse. However, there's also a completely separate set of laws, regulations and directives that govern your employment. These set out your workplace entitlements and obligations, that they govern everything from how much you earn each shift to what kind of thing you can post on social media, and absolutely everything in between. These laws are found in many different kinds of places, across dozens of pieces of legislation, regulations, enterprise agreements, awards, and workplace directives. The thing is, these aren't normally taught during orientation. This overall web of rules and the process of creating them is what's known as industrial relations. So During this webinar, we hope to give a bit of a brief overview into the industrial relations system to find out where these rules come from, what protections that you have to enforce them. And we're also going to look at the workload grievance process within Queensland Health as well. If we can move on to the next slide, please. So as you can see, these industrial relations exist in a hierarchy, and there are three types of instruments. At the top, we have legislation, laws. Laws. Below that, we have awards, and underneath that, we have agreements. Each one of these hierarchies sets a bit of a baseline or a floor. So they establish the bare minimum for your rights and entitlements. Every worker in Australia, no matter where you work, no matter how much you're earning per hour, you're governed by these laws. They cannot be contracted out or negotiated away. So you can never sign a contract that allows a boss to breach the Sex Discrimination Act. And no individual agreement will ever mean that the Work Health and Safety Act no longer applies to you. So right at the top, we have legislation, which sets the baseline. Below that, we have industry awards. They cover an entire industry or profession and set out the entitlements, the conditions, and the classifications for that particular industry or profession. So that really depends on what kind of work that you do. In Australia, we've got over 150 different kinds of industry awards. These include everything from the Professional Diving Award, if you work out on a charter boat up on the Great Barrier Reef. If you're a hairdresser, you might be covered by the Hair and Beauty Award. There's an Architects Award, there's a Gardening and Landscaping Award. Literally every type of profession you can think of, chances are there's an award that sets out the overall umbrella terms that cover that particular industry. For all of you listening and all of you online, the award that will apply to you is the Nurses and Midwives Queensland Health Awards 2015. That award sets out all the different types of nursing levels, as well as things like the types of penalties that you receive for working afternoon and night shifts. You don't need to know the award off by heart, but you should have an idea that it exists and where to find it. And if we go to the next slide, please, Ebony. And finally, under each award is an enterprise agreement. In your case, working for Queensland Health, that would be the Nurses and Midwives EB10, or Queensland Health and Department of Education, because we've actually got some nurses who work for the Department of Education. They're also covered by the enterprise agreement, or what's known as EB10. EB10 sets out your specific individual entitlements. So things like how much you receive for working on public holidays, overtime and recall arrangements. It also talks about non-specific entitlements. So things like the BPF or the business planning framework, the consultation provisions. If Queensland Health is looking to change something about the nature of your work, what obligations they have to consult about that. It dictates what happens behind the scenes. Currently, we're in the stages of negotiating EB11, and we'll talk about that in a bit more detail in a second. If we go to the next slide, please. And now I know this is going to seem like a lot of different legislation, a lot of different policies and procedures and documents, and it is, but they do have a huge impact on your work, your pay, your entitlements, and the way in which your workplace operates. Which we can see in just 1 second. Thanks very much. So this table sets out a few of the quick conditions comparatively between different employers that nurses in Queensland can work for. At the first column, we've got Queensland Health, we've got MARTA, Ramsay Health, and United Care Australia. Now, every nurse who works for these employers generally does the same kind of work. You're caring for patients, you're providing treatment, care, you're doing the exact same kind of procedures, you operate under the exact same professional standards. The difference is your working conditions and entitlements. As you can see, the hourly rate for a first-year registered nurse, it differs from $37.46 an hour at Queensland Health down to $35.32 at Ramsay. Things like qualification allowances. That's if you have a degree which is relevant to your practice outside of a nursing specific degree. you can get remunerated for that. You can get an additional entitlement for that, depending on where you work. Things such as the workload grievance procedures. In Queensland Health, we've been able to negotiate an incredibly robust escalation process that culminates in the specialist panel and referring to the Queensland Industrial Relations Commission, which we will talk about towards the end. However, if you work for MARTA, if you work for Ramsay, if you work for Uniting Care or a different private employer, you don't have those same kind of robust workload escalation procedures, which means that you can be at a bit of a disadvantage if you are trying to raise concerns about the unreasonable workloads within your workplace. And finally, particularly relevant for early career nurses and midwives, things like parental leave. We've got everything from 14 weeks paid parental leave in Queensland Health down to 8 weeks paid leave for Ramsay. All of these things are entirely dependent on your EB and your award, which is why it's so important to understand what your entitlements are, how they came to be created, and what you can do to play a part in fighting for these conditions. Because again, every nurse who works at these places, they do all the same work. However, their wages, conditions, and entitlements are completely different. If we go to the next slide, please. So, as I said, for those who are working for Queensland Health, we're currently in the process of negotiating EB11. EB11 is your enterprise agreements. Enterprise agreements usually last around 3 years. And when the time comes that they expire or they're leading up to expiry, we start the process for negotiating a new one. How the process works, if you're a union member, is it's incredibly democratic. Within your unit and ward, you will have the opportunity to elect workplace delegates and workplace representatives. They're people who put their hand up, who want to take a bit more of a leading active role within the union. They're the go-to people that you can speak to about any issues that are going on in your workplace. I'm not sure whether or not anybody online here has had the opportunity to attend a QNMU conference, but if you haven't, I'd strongly recommend that you try to get along to it. What happens is anything that you want to be added, or if you, let's say that you want to, you want to argue for additional penalty rates on night shifts or working for a Sunday, or you want to see if we can extend that 14 weeks paid parental leave to 16 weeks. What the process is you have a chat to your workplace delegate or representative, and they'll be able to bring a motion to conference. Conference is a collection of all different workplace delegates, workplace reps from across Queensland, and you'll have the opportunity to put a motion forward on the floor. Once that happens, the representatives on the floor are able to vote for whether or not they support it. And if so, that will go into what's called a log of claims. What that is it's almost a bit of a list of things that we'd want to bargain for in the next EB. Once we have that, industrial officers such as myself and others go to negotiate with Queensland Health, and we try to put together a better, more updated enterprise agreement based on the feedback that you've provided us. Once we have hammered out a deal, what will happen is that proposed draft agreement will then be circulated to every Queensland Health nurse and midwife, everybody who's covered by that agreement, and you'll have the opportunity to vote on whether or not you believe that that is a good deal, or whether or not you want to, you don't believe that it is a solid deal. In the event that you think that the offer that Queensland Health has made is insufficient, it's inadequate, it doesn't cover the things that you'd like it to, and that gets voted down by the majority of staff, we then have the opportunity to take industrial action. That can be anything from stop work to being out on the lawn picketing to wearing stickers and all kinds of creative ways to go about putting industrial pressure on your employer to come back to the negotiating table with a bit of a better offer as well. If we go to the next slide, please. Okay. Now, there's a lot of things that happen at work which may not specifically be resolved through the enterprise agreements or the bargaining process, mostly because we can't wait 3 years for them to be resolved. However, just because it's something which is not covered, or just because you don't want to or you can't wait for the enterprise agreement to come up for negotiation again, doesn't mean there are some things you can't do. And I'm just going to pause here for a second and see whether or not anybody online does want to get involved. The question that I've got for you guys is, what is one of the biggest challenges or impediments, or what is one of the things that you believe are stopping people from raising concerns or speaking up within the workplace, in your experience? Feel free to put your hand up, put it in the chats, or smoke signals, carrier pigeon. What are some of the things that you think that might dissuade people from raising up or speaking out about a problem they've got within their own workplace?
Probably backlash.
Backlash, yeah.
Yeah.
You're 100% right. That is the biggest, yes. That is the number one response that we hear about people, that they don't want to put a hand up. They don't want to speak out because they're worried about any kind of retribution, any kind of retaliation. And that's not something which is exclusive to Queensland Health. That's something which occurs in every workplace, rightly or wrongly. So that leads me on to one of my favourite areas of law, workplace law and industrial relations. And if we could go back to the screen share, please. Next one. And sorry, the next slide, please. That is general protections and adverse action. So under the Industrial Relations Act of Queensland and under the Fair Work Act, we have some of the most important pieces of employment law, which is general protections and adverse action. What these pieces of legislation mean is that it is illegal for your employer, in this case Queensland Health, or even a manager or anybody in that position of authority, to take adverse action against you for a prohibited reason. Now, these apply to all workers, including casuals, contractors, people employed by small businesses, even potential employees. If you're going for an interview and you're worried about speaking out, you are protected by this legislation. If we go to the next slide, please. So what is adverse action? Adverse action is doing or threatening to do anything that negatively impacts your employment. This can include firing somebody, refusing to employ somebody, losing hours or being denied certain shifts, being refused a training opportunity, a secondment, a chance to act up, unfair disciplinary action, literally anything that injures you in the course of your employment. It is illegal for employers to do this for a prohibited reason. And if we go to the next slide, we'll discuss exactly what a prohibited reason is. So there are three main categories of prohibited reasons. So these are things that your employer cannot take adverse action against you for. The first is discrimination. So they can't take adverse action against you based on your race, religion, gender identity, disability, sexuality, or a number of other immutable characteristics. The second is whether or not you are or aren't a member of a registered organisation or trade union, or whether you participate in union activities. That includes going to union meetings, that includes asking for industrial relations education leave, that includes getting out on the front lawn and waving a sign around. It includes taking action should you be negotiating for a better deal in your enterprise agreement. But the third and final reason that an employer is not able to take any adverse action against you, if we go to the next slide, we'll see, is the broadest protection, which is your workplace rights, which means it is illegal for your employer to take action against you for exercising your legal rights, something that you have a legal right to do. And when we have a look at all the protections, everything that exists in place, you'll start to realize that you've actually got far, far more workplace rights than you might think. And in the next slide, we have a bit of a list of just some examples. So you've got the right to be safe at work. You've got the right to raise workload concerns under the award. You've got the, so if we just go, you've got the right to raise any kind of exercise, any workplace right. And a workplace right is given to you by an industrial instrument. And they're those three things that we spoke about right at the start of the session. So legislation, your award, and your EB. So anything which is contained within any of those three spectrums, you've got the right to do, and it is illegal for your employer to take action against you. Sorry if we go to the next one again. So if you raise a workload concern, it is illegal for your employer to retaliate against you. If you raise a complaint about bullying, you've got the right under Section 272 of the Industrial Relations Act to do that. If you raise complaints about sexual harassment, you're covered by the Anti-Discrimination Act. You've got the right to request flexible working arrangements under Clause 21 of the EB. You've got the right to make inquiries about your pay and conditions. You've got the right to take leave, request conversion from temporary to permanent status. You've got the right to sue your employer or take legal action against your employer. You cannot be disadvantaged in your employment for exercising these rights. And if we go to the next slide, we'll be able to see a bit of a diagram of this. So the number one reason why people don't speak up within their workplace is because they are worried about retaliation. That's why these pieces of legislation were developed and why they were established, because there is a recognition that there is a fear in there, that people might be worried to speak out, which is why this is a particularly beneficial piece of legislation. If we go to the next slide, we've got some case studies here. So these are all real examples which have happened and which have been protected under these particular bits of legislation. A woman named Rama was subjected to racist comments by a co-worker. The co-worker received a warning, but Rama wasn't satisfied with the person just receiving a warning. Now, that racist, or the person who made those racist comments, her boyfriend then became Rama's manager, and the behavior continued. Rama took legal action and was awarded $15,000 in damages. Recently, Judith was a professor at a university. She lodged a formal bullying complaint against her manager, but the university said that there wasn't enough evidence to support the complaint. And that happens sometimes. She raised the complaint, it was investigated, and it was found to not be substantiated. However, Judith was then fired shortly after. Because she was fired, just after lodging a formal bullying complaint against her manager, that was adverse action taken against her for a prohibited reason. The adverse action was her being fired, and the reason why was because she lodged a bullying complaint. So Judith lodged a general protections claim. She was successful in that claim, and she was awarded $37,000. Finally, Sam was a casual bartender, just a casual worker working, a couple of shifts a week. He asked his boss to check his pay because he didn't believe that he was being paid the correct award rate. And he turned out it was being paid below the award. After he made that inquiry, the boss then told him there were no more shifts available to him. Sam then lodged a general protections claim and was awarded $11,000 in damages. If we go to the next slide. And I know what you're thinking. Sometimes employers lie. So how can I establish that my boss took prohibited action against me because of a prohibited reason? They might say that, oh no, there were genuinely no shifts available to me. They might say that it was because of any number of reasons. How do I prove that the reason why the adverse action was taken against me was one of those prohibited reasons? And the great answer is you don't actually have to. And we'll find out why if we go over to the next slide. Yeah. General protections claim have what's called a reverse burden of proof, which means that you don't need to prove that the action was taken because of prohibited reason. Your employer needs to prove that it wasn't, which means that there is a presumption that if adverse action is taken and there was a prohibited reason involved, the assumption is that it was that the adverse action was due to the prohibited reason, which means that they need to prove that it was not. And it's very difficult to prove a lie in that situation. If we go to the next slide, in summary, the number one reason why people are often worried to speak out is because they do fear retaliation. The law has been updated to reflect that reality and to create some very, very beneficial pieces of legislation there to protect people from exercising their workplace rights. So you do have the right to raise workload concerns. You do have the right to make inquiries about your pay. You have the right to raise bullying complaints, sexual harassment complaints, to request flexible working arrangements, or any number of the hundreds and hundreds, if not thousands, of workplace rights that exist under legislation, your award, and the EB. Now, the great thing about that is, particularly working for a large employer such as Queensland Health, is you don't need necessarily to go to the commission or to take legal action in order for these pieces of legislation to protect you. The very fact that they're in place, and the very fact that your employer does not want to have to be on the wrong side of them, so it means that they're going to be incredibly unlikely, and frankly, it would be incredibly stupid to retaliate in any kind of adverse way against you guys for speaking out, for exercising your rights you have. It's something which would not reflect well on the individual manager. It's a headache that HR, industrial relations, and the executive of each HHS absolutely do not want to deal with, because they know that the law is on your side, they know that your colleagues are on your side, and they know that your union is on your side. And if we get a whiff of any kind of retaliatory or any kind of backlash occurring, we will be on it that quickly. So the important thing to remember is you do have rights, you do have protections there. So that provides a bit of an overview of those general protections, and we can move on to discussing some other matters. There is that particular graphic again, which I quite enjoy, which just goes to show the importance of working with your colleagues, about acting as a collective. Yeah, if we go to the next slide, we can have a bit of a chat about the workload grievance process. So if I can just get a quick show of hands or thumbs up about who is aware of the workload grievance process for Queensland Health, or who knows about workload reporting forms. I'll take that as encouraging. That's all right. So the workloads reporting form is something which is incredibly useful. It's something that we fought very, very hard to be able to include in your industrial entitlements. Essentially, the first step of a workload grievance, the reason why we fought so hard to include this is because nursing and midwifery is an incredibly difficult job. And where people are overworked, where there is an unreasonable workload, there can be incredibly serious consequences for that. What that means is that there needs to be a robust system in place to be able to raise those workload concerns, and most importantly, to be able to resolve them. That's why we've established with Queensland Health, we've established a workload reporting system. From an industrial perspective, that is enshrined within the award, and it is in 5 stages. The first stage is lodging a workload grievance form. That goes to your manager, and a copy also goes to us as well. What that does is say, hey, we were incredibly short-staffed on this particular shift, just want to make a note of it. What happens then is it'll either be resolved or it won't. In the event that it's resolved, fantastic. We've still got a record of it. Hopefully it won't happen again, but it resolves, it can be closed off. If it's not resolved within 24 hours, or it's not discussed and resolved within 24 hours, then we've got the right to escalate to a stage 2 workload grievance. At a stage 2 workload grievance, that's where the QNMU and your nursing or more senior directors of nursing become involved. So we have a look at what's going on. We have a look at the actual concern and the grievance. And under the award, we must meet within 7 days to discuss it. If we don't meet within 7 days, then they're in breach. If best case scenario, we're able to identify what the concern is and take action to be able to resolve it, prevent it happening again. If we are not able to do that, then once again, we escalate, and that goes to a stage 3. A stage 3 workload grievance is where the executive director of nursing becomes involved. We meet within 7 days, And the concern is also tabled at the next NAMCF, or the Nursing and Midwifery Consultative Forum. That's a forum that allows representatives from nursing, midwifery, QNMU, as well as your hospital and health service to come together to identify, discuss, and sort out, hopefully reach agreements as to what action to take about any kind of issues which are going on at work. They're incredibly useful forums. Not every profession has them, and we've been able to get some fantastic outcomes by getting everybody involved around the table and seeing if we can reach a bit of an agreement. A lot of workload grievances are resolved at stage 3. However, a lot of them aren't as well, which is why we've got the right to escalate up to a stage 4. Now, a stage 4 workload grievance is where things become a bit more formal, a bit more serious. And what actually happens is that we have the executive director of nursing, we have representatives from the HHS, we have the staff from the grievance who've raised the grievance as well. We've got people like myself, people like Leanne, Kelly, industrial officers and professional officers from QNMU. But we also, under the award, we also have external executive directors of nursing. So let's say that you work in Metro South and there's a workload grievance which has got to a stage 4. What will happen then is, what will happen then is not only will we have the executive director from Metro South, but we might also grab one from Gold Coast or Townsville or Cairns as well to get a bit of an independent third party executive in there to see if we can get all the brands around the table and have somebody look at it from a bit more of an objective perspective. What that means is that often HHSs may be reluctant to go to a stage 4, or they'd have quite an incentive to resolve a matter before it reaches stage 4, because once it hits stage 4, you've got somebody external coming in, and often that's something which HHSs might be keen to avoid. It also means that we can learn from, let's say Townsville Hospital had a similar incident a year ago. So having somebody come in from outside that particular HHS can lend a fresh pair of eyes and can often act as a bit of a neutral arbiter in some situations. Finally, if we get to a stage 4 and we've had many meetings and we're still at loggerheads, we're unable to resolve it, we've hit a real sticking point, we've got the right to refer the workload grievance to the Queensland Industrial Relations Commission for conciliation, which is the opportunity to sit down and mediate, often facilitated by a commissioner, or arbitration, which is essentially where we put our case forward, they put their case forward, and it's determined by the commission. So hopefully, as you can see, whilst it can start at a stage 1, very relatively small scale, sometimes it can be resolved quite informally. There is a large gamut, a large spectrum of escalation that can be utilised to try and resolve these workload grievances. If we go to the next slide.
I just asked a question
yes,
there.
Please, absolutely.
With regards to the workload grievance, would that fall, would you be filling that out if you were working outside the ratio?
That is a fantastic question.
Legislation?
And you absolutely would. You absolutely would. So that's the exact kind of situation in which you would be raised. Yes.
So then the next question I have, if you fill out that workload grievance form on that particular day and something was to come up in regards to your standards, like with your patient safety or something like that, would you then be protected because you've filled out that form in regards to the law not breaching your registration standards? Do you know what I'm talking about?
I absolutely do. Sorry, I don't have you on my screen. What's your name?
Oh, Linda Jean.
Hi, Linda Jean. Linda,
Yeah.
I want to say that is an absolutely brilliant question. That's a fantastic question. And I think actually is something that we'll get very, very often. So as to your first question, ratios are law. They're legislated. You've got the legislated ratios, and you've also got notional ratios as well. If there is a situation, if something has come up which prevents your unit from working to those particular ratios, then it's essential that it gets recorded. To your second question about whether or not this is something which can act as protection for you. It's, should there be an adverse incident or should something arise during the course of a shift, we would strongly encourage anybody to fill out that workload form if there's a situation where unreasonable workloads may have an impact on your ability to provide safe patient care. And there have been many cases, some which I've been personally involved in representing, others which colleagues might have, whether that be an internal matter from the HHS, or whether it be a referral to APRA, the Ombudsman, a coroner's inquiry. There's been a lot of different situations where a nurse has been on the stand, a nurse has been asked to give their account, and they will say it was an incredibly busy shift. And the next question is invariably, okay, well then why don't we have workload forms to justify that? If it was a busy shift, if you were working several staff down, then why is there no record of it? There's an old adage in nursing where, if you don't record it, if you didn't write it down, it didn't happen. And that's incredible.
I've been consistently working on a ward where I work for like a good 7-8 years, and the registered nurses are very reluctant to do anything on paper. And I'm an EN I'm third year RN student, so I'll be an RN by the end of the year.
Oh, congratulations.
But thanks. But learning and understanding the legislation for what I understand it, I wouldn't expect that would protect you, so to speak. But what I would think is that it would show evidence that organizational factors and structural factors attributed to what happened.
That's right. That was yes, it's absolutely not a defense in and of itself. If something has gone wrong, if there's been a medication error, or if there has been, a rough handling, or there could be any kind of accusation made, putting in a workload form absolutely is not going to get anybody off scot-free. What it will do is contribute to the defence, which will state that we raise concerns that this is not, that we're worried about our ability to provide the best possible care because we are not working in an optimal environment. There are factors on this shift which are contributing to an unreasonable workload, and we've made a note of that. Now, if it's resolved, fantastic. If it's not resolved, then you have done your duty by reporting that up. Now, it's not a blanket immunity. If you make an egregious medication error or something like that, it's not going to automatically protect you in every situation. What it does do is show evidence that there was an unsafe workload at that time, and that you've done your duty to be able to escalate that there. So nobody's ever going to be able to tell you that it's a complete defense. But what I can tell you is if the crux of what we're saying is I wasn't able to get to that particular patient because I was too busy, and we've got workloads submitted to substantiate that, that's going to be incredibly vital and incredibly beneficial in being able to substantiate that defence. Yeah, sorry, it's a bit of a lawyer's answer, but I can't give a hard and fast one. What I can say is if we're trying to say that it was a particularly busy shift and we don't have evidence to be able to support that, then you're going to be in a much worse off position than what you would be otherwise. So it's important there to protect yourself. It's important there to protect yourself if there is a coroner's, if there is a question, if there is an APRA matter as well, because sometimes these matters come back up 6, 12, 18 months down the track, and you can't remember what was going on that particular shift. And I can't remember what I had for breakfast yesterday. But if we have those workload forms in, as I said, they get officially recorded, and the QNMU gets a copy of those as well. We've got that ability there. If we can go back to...
So am I entitled to take a copy of that workload form? Because I generally take a copy of my incident forms because that's my work and that's my report. So legally, do I fall under the banner that I'm legally allowed a copy of that?
I'll go to one of the professional officers about this one as well. But yeah, generally speaking, you submit that. The copy gets sent to the HHS as well as the QNMU gets a copy of that. So if there is a situation where you may need to draw upon it, there absolutely should be that record available to you. Now, in terms of taking it home or keeping that personal information itself, the normal confidentiality and patient confidentiality provisions would apply as well. but there should
Yeah,
always be
sure.
access. And as we said before, they do get tabled at the NMCF. So there's always a record of those ones as well. I'm not sure if Chris, Kelly, Leanne want to jump in on this one from a professional point of view.
I was just going to say, it's Leanne here. It's certainly difficult to get a copy in the electronic workload form environment, because once you submit it, it goes automatically as an email to your line manager and to hopefully QNMU if you tick the right box. So, but you can certainly get copies of these. You can certainly ask for feedback from the line manager, and that they can certainly send that to you, to your email, with the feedback that they've gotten as well. So you can get it that way.
All right. Thanks, Leanne. Thanks.
Right.
Dan, I also think, and Leanne, I think you can actually print it from memory from having used that portal. This was a few years ago though. So just have a look and see if there's a print function which allows you to take that copy yourself. Unfortunately, it is a hard copy.
I'm just wondering
before
though.
you submit.
Yeah, before
You
Yeah.
send.
I was just wondering though, if you have the patient details on that, is that in breach of confidentiality and privacy laws? That's like, yeah. That's a bit of a, because I'm familiar that sometimes things go missing, like just paperwork disappears somehow. And
But
yeah, so
sometimes you don't have to necessarily put the patient details, etc., on that workload form. What you can put is, say you had 3 deteriorating patients on that shift, or a Met
Sure.
call plus 8 admissions, and you can talk about the conditions of those admissions or their acuity and their complexity without naming them or identifying them.
yeah, sure.
It can
yeah.
also be broader if you're working 4 staff down or something like that as well. So there are a number of different things that can be included in those workload forms without putting identifying patient information in there as well.
Yeah, thank you. Just going forward, that the ratios and just the workload, looking at it from a futuristic point of view, it's not going to get any better anytime soon. I'm pretty much well aware of that working on the floor, and I'm sure you guys are as well. So I was asking those questions because I've never filled out a workload grievance form. However, I have had ratio numbers outside. And now that I know that, I'll start utilising them. So thank you all. Yeah.
And can I jump in one more time, Dan, to say one thing?
Absolutely.
Even if you're in a legislated ward and you have minimum ratios, or even if you have your notional ratios in your BPF and you've got that staffing, if your patient acuity is increased and the complexity is increased and you don't have the skill mix, that's also a workload issue. So just because there is a ratio perhaps on the ward doesn't mean you're not having a workload issue as well.
Exactly right.
Just want to add that.
Very good point.
Thank you. Yeah.
Good. So we're just going to run through some quick FAQs about the workload reporting, and please, anybody feel free to jump in. So firstly, what if the issue gets fixed and your manager might say, hey, there's no need to lodge a workload form? Firstly, we get very concerned if your manager or anybody is telling you not to lodge a workload form. And that goes back to those workplace rights that we spoke about earlier. But beyond that, it's not merely a right that you have to lodge a workload form. It's actually a responsibility under the NMBA standards. It's a professional requirement if this is occurring. Yep. And Kelly's just put in the chat, where possible, I wouldn't advise placing patient details in the workload form. And that's 100% right, because a workload form is to describe and to record something which is preventing, contributing to an unsafe workload. That is not dependent on a specific individual patient. So it's not patient notes. It's describing the situation within a workplace, which can be done generally without any identifying particulars. Secondly, and this goes to your question as well, Linda, it can also serve to protect you if something goes wrong on shift. So there is that record as well. Now, if a concern is resolved and your manager is able to respond to it, that's fantastic. That's brilliant. But it doesn't mean it didn't happen. And what we can find often is if there's a shift that is, or a unit that's perpetually understaffed, or they have a high emergent leave, and that continues to happen. Best case scenario, they're able to call an agency, they're able to deploy people, they're able to fix it. But it didn't mean that workload concern didn't happen. And by lodging those workload concern forms, what you're able to do is establish a pattern. And if something is regularly happening, it's vital to have a record of it. So just because it's been resolved on a particular shift is not in of itself a reason to not record it. The second question we get, are workload grievances and workload reporting only about getting more staffing? And the answer to that is no. So the purpose of workload grievance is to address whatever is causing those workload issues. Now, what that can often involve staffing, but we've also been able to resolve workload grievances by replacing old broken equipment. So I was working on a workload grievance for a particular unit where a lot of the cows were busted, couldn't take them anywhere. You had about 3 or 4 of them that were out of action. So everybody was fighting over one, and that was creating a huge backlog. So what was able to be done is we were able to successfully get new updated equipment. And then suddenly that went a long way to resolving those workload concern forms, because we identified what was causing those workload issues, and we were able to reach an agreement as to how to fix them. It can also be a new model of care, can be put in new procedures. So it's really about getting to the heart of the matter. You guys speaking up, sitting around the table and trying to identify, all right, what is causing these workload issues and what can be done to try and fix it. And the last concern or question sometimes we get are workload concerns about complaining or getting my manager in trouble or about, anything negative. And the fact is they're not. And what you guys will find, particularly if you've got an experienced manager who's been around for a bit and come up from the floor, is a lot of managers actually appreciate workload reports, because what it does is it gives them the necessary evidence to then advocate to the people who control the purse strings for what the unit needs. So if they're trying to get, some additional CNs or additional RNs, or they're trying to, get a new cow or something, and suddenly they've got a bunch of workload reporting forms from people on the floor saying, hey, this is an issue, we need to do something about it. They can then present that to their director of nursing, the EDON, the CE, whoever they need to, and it serves as evidence. So if a manager, if anybody is viewing a workload concern form as a negative or as a criticism, it's not. The issues that are recorded on these forms are already happening. The only difference is whether or not we make evidence of it. And then we can use that evidence to try and go about fixing it. And I would remind people again about those general protections and about the protections that you have against any adverse action for exercising those workplace rights. If you go to the next slide, please. So we've got some quick case studies here. Thanks to the QNMU, we were able to, and the work done by the members of the QNMU, we've got over 66,000, over 50,000 of those are within Queensland Health. Because of the work done by members, legislated minimum, also got it right, legislated minimum nurse to patient ratios were implemented back in July 2016 in Queensland Health prescribed facilities. This was due to the tireless campaigning of QNMU members. Since then, this has led to 145 deaths being avoided, 255 readmissions being avoided, and up to $81 million saved. So now we're moving into the phase 2, which is expanding these in the public sector and rolling them out to the private sector. Another win we're able to have is in the largest emergency department in Queensland, so over at Royal. Our workload grievance process has led to securing an additional 39 FTE to date, and we've also secured the recognition that an additional 30 FTE is necessary. That one's been going on for quite some years now, but we keep at it because we're able to continually secure these wins. Workers coming together, exercising their workplace rights to raise concerns, put in complaints, has led to collective grievances. So that's led to wide-ranging cultural reviews, investigations, and in numerous cases has led to the removal of bullies or individuals who aren't contributing to a good working environment. And as this goes to your question earlier, Linda, workloads reports have been vital in representing staff in disciplinary or ARPA matters. If a shift is unreasonably busy and nurses and midwives don't have the opportunity to perform a particular task, lodging a workload form has often been a key part of their defence. And again, if you don't write it down, it didn't happen. And so you're 100% right. It can play that important role. If you go to the next slide, please. That one was just put in today. Go to the Maroons. And the last one is we'll open up to any questions or any discussion as well. And thank you again, Ebony, for your fantastic tech skills. They're far, far better than mine. So I know we covered a fair bit of content and it might have been a bit dense in places, guys, but again, if there's any questions, any discussion points, any experiences that you want to share? Or anybody from QNMU, if you want to jump in and raise anything or mention anything further, please, this is the opportunity.
Thank you very much, Dan. I think it's important for all of you, as Dan said, the importance of filling out those workload forms, but also having that sense of collective. And, you know, when we're talking about employers can't take adverse action against you, but we know many do. The law says you can't, but they, through ignorance or deliberate, they still do target people. So that's why it's more important than ever to be a part of that collective and have you and your colleagues working together and encouraging them all to fill in the workload forms, or everybody put their names to it. Because it's more difficult if management were of the view that we were going to target certain people because they speak up, or you're the one that always puts in the workload form. It makes it more difficult for management to target an individual if everybody on shift is submitting those workload forms. And they can't then dilute our message, because what happens sometimes for our workplace reps and our active union members, sometimes managers try to dilute the message by saying, and I can see you on my screen, Tamika, so I'm going to use your name. Oh, yes, Tamika, here it. What's your problem now? Oh, another workload concern. No one else is putting these forms in. And so they try and dilute the message. But that's why it's always better if we've got you and all of your colleagues submitting those forms. Management can't ignore it, and we won't let them ignore it. And Leanne, as Leanne said, even if your ratios are being met, it doesn't mean that you don't have a workload issue. Don't let anyone tell you that, you know, we've got all the staff that you need. You can't lodge a form. Yes, you can. As Leanne said, because of those increased acuities or skill mix or scope of practice issues, you've still got a workload issue and a workload concern, then fill out those forms.
Thank you for that, Chris. Thanks. That's awesome.
Okay.
Thank you, everybody else, and thanks, Dan. That's really good. So I appreciate it.
No, thanks very much for coming. I mean, we really appreciate your, your engagement in this. Again, you're only as powerful as what you know as well. And as Chris said, the most important thing that you can do is stick together, particularly in this stage of your careers as well. You can't understate the power of collectivism. And, you know, one person going one out is never, ever as powerful as an entire collective of nurses sticking together. We are the most unionised workforce in Australia. And because of that, we've been able to secure some fantastic wins as well, because we're all in the same boat. And that's never been as true as when you're working on the floor together as well, guys. So everything that you do, it's not for yourselves, you know, it's for each other and for your patients. So never be afraid to stand together. And, you know, if somebody else is having a hard time, if somebody else is putting in a workload form or, you know, asking a question, stand with them. You know, literally physically being there, it can be a massive show of solidarity. So there are small things that you can do as well. And as I said, remember that, you know, your colleagues are on your side, the law is on your side, and the union's on the side as well.
Thanks, Dan. One, I'm just conscious of the time. Can I just encourage all of you to keep an eye out? It's as part of the EB11 process. The QNMU are going to be running and conducting a whole, with our union organisers, a whole range of workplace meetings, mass meetings to talk about the EB11 negotiations, to talk about the wage offer, to talk about many of the things that are being negotiated between the QNMU and Queensland Health. So keep an eye out. Get on our website. There's an EB11 activist meeting tomorrow night at 6 p.m. Ebony's just put a link to that there. where we're going to, for those people who want to get involved in the EB11 campaign, for those people who want to give you and your colleagues a greater voice in the workplace, there'll be some activist training tomorrow. And then next week and the next couple of weeks, there will be meetings being held all over Queensland. So keep an eye out for that. I encourage you and your colleagues, and talk to your colleagues, because here's a chance for all of you to send a message to Queensland Health to say, hey, 2.5% wage increase doesn't cut it. We're going backwards. You know, we want 5.1 as a minimum, 5.1%. So keep an eye out for those EB11 QNMU meetings coming to a town near you. And I'll see you, Linda, next week in Brisbane on our workplace reps course, I understand.
You will. That's
Yes.
correct, I believe. So yes, I look forward to it.
So that'll be great.
All right, no worries. Thank you.
Thank you. Are there any other final comments, thoughts that people want to talk about? Ebony's put up there some of the Fairer Wages meeting on the 16th of June. And I think that's an online meeting. Is that right, Ebony?
Yes, via Zoom.
Okay, great. So if you can't get to one of those ones in your workplace, there is an online EB11 update meeting on the 16th of June. So keep an eye out for all of that stuff. Navigate your way around our website. Get to know the website. There's a whole range of information and fact sheets and information letting you know what's happening, what events are coming up. So I encourage you all to build that relationship with the QNMU, build that relationship with your organiser, build the relationship with Member Connect. If you've got those questions wanting to know something around your ward or agreement, ring Member Connect in our Brisbane office, and they're only too happy to answer your call. So thank you, everybody. Thanks for coming along. Enjoy the rest of your night. Don't be too upset tomorrow, though, when New South Wales wins tonight. So,
Mate, you learned nothing from the presentation.
I'll get out of here now. Thank you very much, everyone.
Right.
Thanks, everyone. Bye.
Thanks, guys.
Bye-bye.